the most distinctive forms of proof in common law, which were prevalent as well in Western Europe, were of Germanic origin. So there were trial by ordeal, compurgation, and trial by battle. These earlier forms of proof share the feature to rely in different ways and in different extent on divine intervention on the outcome of the case. So the trial by ordeal may be the most obvious example, as it was expected that God would intervene in the outcome if the defendant was rightful. So in the ordeal by cold water, the accused was dunked into a pool of water. If he was innocent, he would sink, and if he was guilty, he would float. In the ordeal by hot water, the accused would reach into a pot of boiling hot water and retrieve an object. If the accused was innocent, he will not have any sign of burns. And if he was guilty, the burns would reveal his guilt. So similar to this was the ordeal by hot iron, where the accused would carry a burning hot iron. And in compurgation, also called wager of law, the defendant's case was proof if he and a sufficient number of supporters, called compurgators, successfully swore the prescribed oath in denial of the charge that had been made against the defendant, and breaking an oath amounting to a perjury, a serious religious and secular offense that could be punished by excommunication and forfeiture of legal rights. And in trial by battle, people relied on God to help the rightful party to win the battle. So, as we have seen, law and religion were intertwined in medieval modes of proof. Conceptually, because the outcome was thought to bespeak the command of God, and institutionally, because the conditions of these proofs, particularly the trial by ordeal, were overseen by members of the clergy. So, to a certain extent, the outcome of a case, especially in criminal law, was determined by the church.
Yeah. We see a bit of a shift, though, following on from the Fourth Lateran Council in 1215. So it's determined at that council that having clergy supervise ordeals is tempting God, and you're not allowed to do that. So by not permitting the clergy to actually take part in this, they would basically abolish ordeals in general. But you needed an alternate system of proof, and in the ecclesiastical courts, this was done by adopting the Romano kind of canonical procedure regarding witness testimony. There were also a number of other forms of proof you could use, including confession, presumptions, written evidence, oaths of parties, inquests, but witnesses were certainly the most common. And there were very clear outlines developed in the Romana canonical procedure, which provided a means for examining witnesses in such a way as to elicit the truth, and also rules for rejecting witnesses and resolving conflicts. So the overall burden of proof rested with the plaintiff. This obligation could, of course, be bypassed by the admission of guilt of the opposing party, but this almost never happened. So after the oaths were taken, the plaintiff was assigned 3 terms, usually, to produce his witnesses, and the defendant could in turn make exceptions to these witnesses and to their statements. They could produce any number of witnesses between 2 and 40, which is quite a few, and these would be sworn in the presence of the opposing party, and their examination committed to an examiner, but not to the judge. These witnesses were then examined according to a set of articles. These were questions that were drawn up on the basis of the questions that the case kind of brought forward. And there could also be another set of these for cross-examination provided by the opposing party. The most common questions regarded the witness's status, the relationship to the parties, possible reasons for prejudice or corruption, along with the necessary questions about the case. These questions were highly specific and would often concern not only the facts of the case, but also things like the weather, how witnesses knew about the events, what time of day something took place. And all of these witnesses were examined separately and in secret, so they couldn't corroborate their accounts unless they did it beforehand. These testimonies were probably given in English or French, but the records that we have are in Latin, of course. In addition to witnesses, parties could bring documents as well, as I said, and these were often brought in a sealed box, and these could be submitted at any time before the formal conclusion of a case. Documents that could be used in this way would be a deed of composition, a bill of complaint from the royal courts, a chirograph, something like that, or a certificate that the person in question had gone on crusade, any of these things. But oral testimony from witnesses was still preferred, and even when documentary evidence was available, witnesses were still often introduced to verify the written records.
Yes. In England, at the end of the 12th century, things went a bit different. So first, we observed that these earlier forms of proof started to decline gradually for multiple reasons. The ordeal was the practice used to determine the question of guilt and innocence of the accused person when no other mode was available. So, therefore, the procedural hole following the Fourth Lateran Council had to be filled by another procedure. And this decree of condemnation of suprahuman proofs brought England in a secular and in a different from the continent path, as it has probably contributed to encourage the development of trial by jury, although we have to be careful because its impact remains uncertain and widely discussed. So the jury system was based on neighbors' testimonies. Local knowledge had been used for a long time in inquiries in all sorts of civil and criminal cases, like in ecclesiastical courts. And what is interesting is that gradually the role of the criminal jury expanded to the delivering of the final verdict on guilt or innocence in the early 13th century. So trial by jury also progressively superseded trial by battle, considered too risky and uncertain. All through secular, the trial by jury replaced divine judgment in a certain extent, as it aspired to reach the same level of certainty through verdicts conceived as unscrutable. So the use of proof by jury maintained the holistic attitude to the settlement of disputes which underpinned medieval proofs.